Hello, everyone. Welcome to Texas Business Court Insider. We are tracking developments in the Texas Business Court and beyond. My name is Rachel Roosth. I'm a partner in the Commercial and Energy Disputes Group in Houston, Texas, and I'm here with my partner who's also in the same group, Kate Ergenbright. Today, we're focusing on the local rules of the Texas Business Court. As of the date of this video, the most recent copy of the local rules is dated June 1st, 2025, or that's the effective date. But do make sure that you are looking at the most recent local rules when you're considering these rules. And also be sure, as you'll hear us remind you throughout the video, to check the rules of the particular division and of the judge that you're appearing before, because they will have their own rules, forms, and guidelines that are also relevant. But today, we're going to focus on the Texas Business Court local rules and some of the ones that we find most significant. We won't talk about everything, but we'll focus on the ones that we think are particularly interesting. So we will discuss the scheduling order, the corporate disclosure requirement, some unique discovery procedures, some preferences that the court has on exhibits, and then emergency relief. So, Kate, let's start with the scheduling order. What can you tell us about that?
So, within 30 days of a defendant's first appearance, a notice of removal is filed or an order transferring a case to the Texas Business Court is issued. The parties have to jointly file a proposed scheduling order. Now, each division and sometimes each judge has their own preference for what form they want that joint scheduling order to be in. So be sure to look for the division or specific judge you are in front of's preferred form. Now, when I first read this rule, one of the things that jumped out at me is that the local rules don't contemplate what to do if you disagree with the opposing party as to what the case schedule can be, which is pretty common. Despite parties' best efforts, they may not agree about how long it takes to litigate a case or what the interim deadline should be. Now, the 3rd, 4th, and 11th Division have contemplated something or what to do in this situation, and their preferred form for a scheduling order states at the top that the parties could submit separate answers for the individual deadlines throughout the form. But those forms are also specific to state that the parties cannot include argument with their separate answers. So be sure to look at that form and those rules if you're in the 3rd, 4th, or 11th Division. Now, at the same time parties have to file this joint scheduling order, they also have to file a corporate disclosure statement. Rachel, what do the Texas Business Court local rules say about that statement?
In the corporate disclosure statement, the parties must identify the opposing law firms or counsel, and then they also must identify persons or entities who have a financial interest in the litigation, including insurers. If there's a large group that can be specified by a generic description, then you don't have to list out each one individually. You can just identify the large group. And do know that there is an exception that government entities do not have to file a corporate disclosure statement. I'd also note that at this time, there's no guidance in the local rules on how to handle it if the financial interest of persons or entities changes throughout the course of the litigation. For example, if new parties or third parties become financially interested in the litigation. So do see if there are any changes to that in the future in the local rules. And Kate, we have discussed some of the rules on initial filings with the court. What happens next once we move into discovery? Are there unique procedures there?
There are, Rachel. The Texas Business Court has some unique rules related to the filing and the resolution of discovery disputes that are more common to procedures I have seen in federal court than in Texas state court. And the headline is that parties cannot file a discovery motion in the Texas Business Court without going through a very specific procedure, with the exception of some limited time-sensitive issues that are specifically mentioned in the local rules, such as auto-quashing a deposition for an objection to the time or place that it has been noticed. Now, the first step in this discovery dispute process is that the parties have to confer, engage in a thorough, good faith attempt to resolve or narrow their discovery dispute. That's not a new requirement. Every litigator is familiar with the conference requirement. But in the next step, if the dispute remains after the parties have conferred, The moving party cannot file a motion. They have to file a letter in the Texas Business Court summarizing the discovery dispute. And that letter has to include a certification that the parties personally conferred, the date the conference occurred, who participated, the results of the conference, and whether cost shifting, proportionality, or alternative methods of resolving the discovery dispute were discussed during the conference. This is likely an attempt to prevent parties from sending out an email asking for a meet and confer or having a meet and confer in their email and then hauling off and filing a motion to compel without waiting for a response and saying, well, I just didn't get a response to my email. These rules are really designed to streamline discovery disputes. Now, the letter that the rules permit parties to file can be no more than 700 words without leave of court, which is really not that much space. Responses have to be filed within 7 days, and they are also subject to the 700-word without leave of court limitation. No replies are permitted. Now, at this point, the court has a lot of different options on what to do as outlined in the local rules. They could schedule a teleconference with the parties to discuss the discovery dispute. The court could order a motion and briefing be filed on the discovery dispute beyond the 700-word limitation. The court could provide further instructions to the party based off what's in the letter, or even issue an order based purely on the letters alone. Now, at this point, only after this process has completed, and if the court has not already ordered a motion and briefing to be filed, can a party actually file a discovery motion in the Texas Business Court. Now, if you have a discovery dispute in the Texas Business Court, be sure to check out the division and particular judge that you are in front of's procedures to make sure that they don't have any modifications or additions to this discovery dispute resolution process. Now, when we start talking about motions, we have to talk about exhibits. Rachel, what does the Texas Business Court local rules say about exhibits?
The local rules have some interesting comments on exhibits. And I say comments because the rules don't say that they must do something, that the parties must do X, Y, Z, or shall do X, Y, Z in relation to exhibits. Instead, the rules say that the court prefers that the parties do these things. So these appear to be strong preferences and not necessarily actual rules. But if you're trying to make things easy on the court, you might as well follow them and treat them as though they are rules. So the local rules suggest that you combine your main document with any appendices into one single PDF for filing. And if it's so big that you need to break it apart into multiple PDFs, the court wants you to find a logical place for breaking that up between documents as opposed to in the middle of a particular document. And then you're supposed to number all of the pages consecutively. So you don't start over at the appendix or number each exhibit differently. Your first page of your main document is 1, and you keep numbering all the way through to the end of your filing. In addition to that, the court wants to have a table of contents for the appendix, and it also wants the PDF to have bookmarks in it for each document within the appendix. So many of us are used to different practices in other Texas state courts, but these are the preferences that the court has in its court. So, Kate, tell us about emergency relief in the Texas Business Court.
There are a couple of rules to note regarding emergency relief and ex parte relief requests in the Texas Business Court. The first is that before or immediately after filing a request for a TRO or ex parte relief, you have to notify the court clerk. You also have to file a proposed order with your request for relief. And at the time of filing, or no later than 2 hours after requesting a hearing for a TRO or ex parte relief, the applicant must file a certificate signed either by their attorney or by the party themselves, stating that the application contains either detailed and specific grounds to support emergency or ex parte relief, or setting forth the date, time, and manner of notice provided to the opposing party.
Got it. Thanks, Kate. So with that, I think we've covered the most important local rules of the Texas Business Court. Kate, do you want to lead us out?
Absolutely, Rachel. Thank you all for joining us for this video. Don't forget to like and subscribe below if you want to be notified of future videos that we put out. We will also include below a link to the Texas Business Court Insider Hub. On the Hub, you will find our other videos and written content that expand on the Texas Business Court and beyond.